Vous levez. Please be seated.
Thank you, Mr. President. I've been informed by the registrar that according to the 2.5 hours which have been allotted to the Nikolic defense team, we have 15 minutes left. Mr. President, I ask for your indulgence, and I can say that we can complete our submissions in 40 minutes. That will be 25 minutes additional time, and we will complete our submissions, Mr. President.
Go ahead, Mr. Popović.
Thank you very much, Mr. President. Before the break ended, I was addressing the prosecution overview, and I was at paragraph 2610, and I told 2611, sorry. Sorry, I apologize. I was at 2608 and telling you that a meeting with Beara and Popović at the Zvolnik Brigade Command on 15 July is nothing but speculation. Many witnesses testified about what happened on the 15th July in the morning. Nobody, no evidence, no one mentioned the presence of Beara at the Zvolnik Brigade Command. Even witness Pandurevic, who testified and explained everything that happened when he returned to the Zvolnik Brigade Command, and despite the fact that his theory is that Beara had taken over the Zvolnik Brigade Command, he never even mentioned that Beara was there on 15 July in the morning. Mr. President, I move on to 2609. The fact that prosecution says that Drago Nikolic went with Turbic to Rochevich school. Simply looking at the time, it's not possible. Prosecution would like you to believe that Drago Nikolic was everywhere at the same time, that he was on duty that morning as of 11:45, that he was in the morning, according to the testimony of Micho Gavric, he met with persons at the Zvolnik Brigade Command in the morning. And then the prosecution would like to place him at Rochevich school. If you look at the testimony of witness PW165 carefully, there is no weight that can be attributed to this allegation, or it simply has not been proved. Prosecution again continues in the speculation at 2610, saying that because Drago Nikolic was on duty that morning, that's a very early morning, he gets a request for ammunition from the 1st Battalion, that this is sufficient to put Drago Nikolic on knowledge about what is happening at the 1st Battalion and that people will be killed there that day. This is simply an inference which cannot be drawn beyond a reasonable doubt. Prosecution continues by saying that Drago Nikolic was involved in the murder of the 4 Barnievo Farm survivors. We address that. The sole evidence on the record on this issue comes from witness PW168, and it cannot be attributed any probative value. As for the fact that Drago Nikolic was not involved in the burial, again, the sole evidence on the record is witness PW168. There is an intercept about the reburials, but this intercept, in our view, can only be interpreted with the benefit going to Drago Nikolic that he was not involved in the reburials. It is also significant regarding the reburials, and Drago Nikolic, according to the evidence on the record, was away when these reburials took place. Finally, I need to address, Mr. President, a very important topic, which is the fact that it appears that the prosecution has withdrawn or given up leading evidence or arguing that Drago Nikolic was responsible for what happened to the patients from the Milici hospital who were transferred to the Zvolnik Brigade. This was an allegation which was in the indictment against Drago Nikolic. It was also mentioned in the prosecution pretrial brief, although I do not have the reference. And to the best of my recollection, the prosecution also mentioned this in its opening statement. However, there is no mention whatsoever in the prosecution final trial brief that Drago Nikolic is in any way involved in the disappearance or murder of the patients taken from Milici Hospital. I expected that in oral arguments the prosecution would make a correction to that effect. It has not done so. Accordingly, Mr. President, the only conclusion, which can be drawn immediately actually, that Drago Nikolic was not involved in what happened to the patients from the Milici Hospital transferred to Zvornik. I take this opportunity to mention one mistake I did earlier on when I was referring to the testimony of witness Stojkic. I said that he testified coming back with the tank company. That is not correct. He did not testify to that effect. So that's a mistake I made, and I apologize for this mistake. It's something that we argued in the brief, that he came back with the tank company, but he never said that. He simply said that he returned on 13 July. I now move to count 1, genocide. Of course, our position is that no genocide was committed. And even if genocide was committed, that Drago Nikolic incurs no individual criminal responsibility for genocide. The appeals chamber has already held previously in a Kostic case that a genocide was committed in Srebrenica. However, this is a factual conclusion which is not binding on this trial chamber. This trial chamber must decide if a genocide was committed in Srebrenica on the basis of the evidence in this case, not in previous cases. When we compare the evidence led in the Kostic case with the evidence led in this case, there are huge differences. We know much more information today that was not known to the appeals chamber or to the trial chamber in the Kostic case. Using the same line of reasoning as the appeals chamber did in the Kostic case, and we're applying it to the evidence in this case, it is our submission that it was not genocide. So, going straight to the prosecution's allegation, well, they changed, of course, their view from the indictment until their final trial brief. There used to be 4 components to the alleged genocide. Now there's only 2. They dropped the reburials and they dropped the opportunistic killings as being part or components of the alleged genocide. Now what they say in the final trial brief is that the genocide is made up of the 2 joint criminal enterprise. 1, to kill all the able-bodied men, and 2, to forcibly transfer the population from Srebrenica and Žepa enclave. Just the wording they use, Mr. President, shows that my previous submission is correct in the sense that when they talk about killing all the able-bodied men and they make a separation between that and the population from the Srebrenica and Žepa enclaves, shows that the men were not forcibly transferred. Something different happened to the men, not forcible transfer. Mr. President, there are obvious problems with the alleged joint criminal enterprise to kill all the able-bodied men from Srebrenica. First of all, it is undisputed that not all the able-bodied men from Srebrenica were in fact killed. So the common purpose of the alleged GCE was not achieved. Then, based on the evidence as a whole, including forensic evidence and the demographic evidence, it simply cannot be concluded beyond a reasonable doubt that more than 7,000 Muslim men from Srebrenica were killed as a result of the crimes forming the basis of this indictment. Of course, none of the defense team will be able to use an hour to make submissions just on this specific topic, as the prosecution was able to do. But it doesn't matter, because our submissions in our brief clearly show that beyond a reasonable doubt, the maximum number of persons who have been killed as a result of the crimes committed in this case does not exceed 3,000. Secondly, and most importantly, in respect of the GCE to kill all the able-bodied men, there are many counter-indications that the events which took place in eastern Bosnia in July 1995 reflect a genocidal intent. One counter indicator is that the men who were killed while traveling with the column, going to Tuzla, were killed as a result of legitimate combat activities, which negates the proposition that they were killed for the purpose of destroying, in whole or in part, the Bosnian Muslim group as such. Prosecution conceded on this that no less than 70 to 73% of those killed appear on the ABIH records. Now that's significant. 73% of the members of the column were on ABIH records. So they were actually aiming and they were actually fighting soldiers, not attempting to destroy the Bosnian Muslim population as such. Another counterindicator is the fact that a large number of men from Srebrenica were allowed to link up with the Second Corps. The reason why they were let through, whether it is because they were too strong or whether it is because it was to avoid a carnage on both sides, is irrelevant. The fact is that they were let through without fighting shows that there was no intent to destroy in whole or in part the Bosnian Muslim group as such. The orders issued from the main staff down to prevent these men from linking up with the Second Corps of the ABIH, not to kill them, shows that there was no intent to kill the able-bodied men. Another counterindicator, contrary to the appeals chamber findings in the Kostic case, the military able men from JEPA, according to the evidence in this case, were under the control of the VRS. Yet, no genocidal acts were committed against them. Another counterindicator is the holding of the Darfur Commission, which held that the killing of young men selectively within the population does not demonstrate genocidal intent. This is paragraph 513 of the Darfur report. Another counterindicator is that the fact that prisoners who were held at the Kula school were transferred in the custody of military police from the East Bosnia Corps and transferred away from the area of Zvolnik. They were taken to Batkovci. This shows that there was no intent to kill or to destroy in all or in part the Bosnian Muslim group. I refer to Novica Simic at transcript 28567, 28569. What I referred to earlier also, the chaos that was in Bratunac on 13 July, shows that there was no genocidal plan. Of course there was some killing, of course there were some crimes, and of course they were atrocious, but there was never that intent in that area at the time. Lastly, my colleague said during his oral argument, that's at transcript 34276, that what happened in Srebrenica was ethnic cleansing. Well, I'm not going to say I agree, but what I'll say is that this is an admission from the prosecution that it was not genocide. Ethnic cleansing is not genocide. What happened in July 1995 is that the VRS was looking for a piece of land to be in a good position to negotiate. As the ABIH was doing, trying to fight in Sarajevo, and as the Croats were doing, fighting for Operation Storm, also in July 1995. Not to destroy in all or in part the Bosnian Muslim group as such. Mr. President, there are also obvious problems with the LSGC to force out the Muslim population in respect of genocidal intent. One of these problems was illustrated by the holding of the Darfur Commission presided by no other than Antonio Kesese. He said that forcible transfer is actually a counter-indication of genocidal intent. Paragraph 515 of the Darfur report. Of course, the fact that people are forced to move to another location, albeit as a result of a crime, does not display intent or genocidal intent. It actually supports the proposition that the physical or biological destruction of the group was not the aim. An additional problem is again the holding of the Darfur Commission, which is supported by the fact that two of the co-accused in this case, although they are charged with forcible transfer, are not charged with genocide. This shows that the prosecution's understanding that being a member of the GCE to force out the Muslim population from Srebrenica and Jepa enclaves, if it was proved, of course, does not entail having genocidal intent. That's a significant, again, admission on the prosecution's side. Lastly, and thirdly, there's even a more important problem, which is that even if the actions taken to further both alleged GCEs taken together, that would not demonstrate genocidal intent, as explained again in the Darfur report. This is what the Commission concluded, holding that the attackers did not entertain genocidal intent, as their intent was to murder all those men they considered as rebels, as well as forcibly expel the whole population, as to vacate the villages and prevent rebels from hiding among or getting support from the local population. For all these reasons, there was no genocide committed in the area of Srebrenica. Furthermore, even if the trial chamber was to conclude that genocide was committed, the prosecution failed to prove that Drago Nikolic had the required mens rea. Prosecution argues that genocidal plan for Srebrenica evolved from policy directives and subsequent decisions of members of the RS and VRS leadership. It is significant that Drago Nikolic was not aware of these policies and these subsequent decisions. Prosecution then says that genocidal plan culminated in both GCEs. Well, as we argued, Drago Nikolic was not a member of either alleged joint criminal enterprise. It must also be noted that the central role played by Drago Nikolic in the crimes committed in July 1995, as alleged by the prosecution, simply has not been proved. Clearly, the acts and conduct of Drago Nikolic during the period from 12 to 17 July, coupled with his limited knowledge of any goals pursued by the RS and VRS leadership, do not support the conclusion that he harbored genocidal intent. Prosecution goes on to argue that Drago Nikolic's intent to commit genocide is evidenced by his personal use of derogatory language. Well, we know that the appeals chamber clearly held that such charged language is commonplace during wartime, and therefore no weight may be attached to it in establishing genocidal intent. Finally, the prosecution argues that Drago Nikolic's genocidal intent may be inferred from the high level of planning and coordination which went into the murder operation, and the systematic nature in which the bodies of the murdered Muslims were buried and then reburied. Prosecution has failed to prove that Drago Nikolic would have contributed to the alleged high-level planning and coordination. Drago Nikolic did not harbor the intent to destroy, in all or in part, the Bosnian Muslim group as such. Prosecution, I move now to the last topic quickly, which is conspiracy to commit genocide. I note for the record that there's almost nothing about this count number 2 in the prosecution final trial brief. I refer to our arguments. First one being that the prosecution simply mixes things up or confuses conspiracy to commit genocide with joint criminal enterprise. One is a mode of liability, one is a crime. And during his oral submissions, my colleague from the prosecution, Mitchell, said that Drago became a member of the conspiracy later on. That doesn't exist. It is possible for an individual to ultimately become a member of a joint criminal enterprise once he's made aware of the common purpose and he intends to further it and he significantly contributes to it. But the conspiracy itself is finished by then. Conspiracy, you cannot buy into a conspiracy at a later point. Even if the trial chamber would find that the crime of conspiracy to commit genocide was committed in eastern Bosnia in July 1995, contrary to our arguments, the evidence clearly establishes that Drago Nikolic does not incur liability because to be a member of the conspiracy, you need to have genocidal intent. And Drago Nikolic did not have genocidal intent. Finally, with respect to persecutions, I refer the trial chamber to the arguments in our brief. And once again, I note that the prosecution has not even attempted to properly explain or prove or explain how each of the co-accused in this case had the necessary discriminatory intent. What was done in July 1995 by whoever it was done was not done because they were Muslims, because the victims were Muslims. It was done because it was the enemy. It was done to gain territory. There was no persecutions as alleged by the prosecution. On this, Mr. President, I will hand over to my colleague who will now address with respect to sentencing considerations and final remarks. Thank you, Mr. President.
Thank you, Mr. Burgon. Ms. Nikolic.
Thank you. Good morning to everyone in the courtroom. A lot has been said over the last 3 years and during our oral submissions, and therefore I will only address the mitigating and aggravating circumstances relating to the sentences and the character of Mr. Nikolic as stated in the prosecution brief and its closing arguments. In his closing argument of the 2nd September 2009, on transcript pages 34046 and 3407, Mr. McCloskey pointed out that 3 things are necessary to prove the guilt of the accused. Excuse me just for a second. I'm sorry, my live note is blocked. Which is that the accused consciously disregarded their duty, that the accused did not sabotage the crime or help the victims, and that the accused decided to participate in the crimes. Firstly, I am not going to repeat the fact that Drago Nikolic, as security organ of the Zvorni Brigade, did not have any responsibilities and powers regarding the prisoners of war. Therefore, the prosecution did not prove that Drago Nikolic disregarded his duty. Secondly, the prosecution has not charged Drago Nikolic for command responsibility or on the basis of command responsibility, and therefore cannot accuse him of failing to prevent crimes at the end of the trial. And finally, the prosecution did not adduce evidence, as my colleague pointed out, that Drago Nikolic was aware of the common plans, that he intended to further the common plans, and that he had significantly contributed to the common plans, and that he had the required intent for the crimes included in the JCE. Drago Nikolic was taken aback by the events of surprising scope and speed in Zvornik on the 14th of July 1995. It has been said at one point in time, Drago Nikolic found out and realized that prisoners of war who had been brought to Orakovac had been executed. That happened in the evening of the 14th of July 1995. Drago Nikolic was in the proximity of the school in Orahovac and Petkovci, but he never went to Pilica or Ročević during the critical events. It is necessary to highlight that what took place on the 14th of July is important for establishing his responsibility. What is even more important is to establish what Drago Nikolic could have done. In other words, what his real options were, having in mind his rank, his position, his ability to influence the events, the overwhelming nature of what was happening, the scope of the operations, and the rank and authority of all other officers who were involved. The facts in this case show that Drago Nikolic could not have influenced in any way the decision to bring the prisoners of war to the territory of Zvornik. He learned about his arrival only upon their arrival. He could not have prevented the prisoners being put up in schools. He could not have secured food and water for them, nor could he have secretly called a TV station as suggested by the prosecution in its final brief at paragraph 2715. Briefly, his possibilities were considerably limited. Also, Mr. President, I would like to address the aggravating circumstances as listed by the prosecution in their final brief at paragraphs 2816 to 2827. The prosecution claims that the scope of the crimes, the number of victims, and the vulnerability and status of victims are aggravating circumstances. Your Honors, these elements cannot be treated as aggravating circumstances, as they have already been incorporated in the definition of the crimes that the accused has been charged with, including Drago Nikolic. This has been argued in the Blagojević and Jokic judgment, paragraphs 841 and 843. Secondly, the prosecution's claims in paragraphs of their final brief 2822 to 2825 that Drago Nikolic's high rank and position in the brigade are aggravating circumstances. However, as indicated already, Your Honors, Drago Nikolic was a second lieutenant, which is the lowest possible rank for an officer, as explained in our final brief in paragraphs 412 to 415. His position in the brigade can be seen from the testimony of PW 104, who said that Drago Nikolic, as a second lieutenant, did not have any importance. Transcript page 8018. He certainly did not hold the high rank as claimed by the prosecution nor the authority. Thirdly, in the prosecution's view, in paragraphs 2826 to 2827, the willing participation of Drago Nikolic in the crimes also constitutes an aggravated circumstance. In our final brief, as well as in our closing arguments, the defense strongly rejects the prosecution's claims in this respect. Drago Nikolic was drawn into the whirlwind of events without ever being asked whether he was willing to do that or not. Mr. President, in this respect, I would like to draw a parallel with Dragan Jokic, who was sentenced by this tribunal on the basis of the same events. In paragraph 836 of the Blagojević and Jokic judgment, the trial chamber took account of the limited involvement of Dragan Jokic and his low rank were the key factors in determining the sentence. As has already been said, the involvement of Drago Nikolic in these events was also very limited. He was not a member of the alleged joint criminal enterprise, even though he bears part of the responsibility because of his proximity to the events. He was a second lieutenant, which is the lowest rank for an officer, and he did not have the authority of a superior officer. Mr. President, I respectfully draw the trial chamber's attention to our arguments in relation to the character of Drago Nikolic in paragraphs 396 to 421 of our final brief. I also respectfully recall the testimonies of witnesses who appeared before this trial chamber He is a man who never expressed hatred or inter-ethnic intolerance, who conscientiously discharged his duties, who respected his superior officers. He grew up in the spirit of tolerance, which is confirmed by the current relationships in his family, as indicated in our final brief in paragraph 419. Finally, Mr. President, I call upon the trial chamber to take into account the character and the limited involvement of Drago Nikolic as opposed to other individuals who were involved in these events. In relation to this, I would like to say one thing. Drago Nikolic did not participate in the events as presented by the prosecution, and he definitely is not the kind of person that the prosecution would like to portray him to be. Thank you.
Thank you, Ms. Nikolic. Judge Kuhn, any questions? Judge Stoner? Judge Prost?
Thank you. Mr. Bourgon, I have a couple of questions for you. Back at the beginning of your submissions, Mr. Bourgon, and it's specifically page 6, line 12, you were discussing, and perhaps out of an abundance of caution, because this was in private session, we should go into private session just briefly.
Let's do that.
Argument that was made by both you and Mr. Stoic as well made several references in this regard, and I simply want to be clear as to your proposition here. You have pointed to particular witnesses that the prosecution, for whatever reason, chose not to call in this case. And what I'd like to know is whether you're suggesting there is any form of inference that this trial chamber can derive from the failure of the prosecution to call particular witnesses. And if that is your proposition, that we can draw a negative inference, I'd like to know what authority there is in support of that proposition.
Thank you, Judge. To put it bluntly, there is no negative inference that can be drawn from the fact that the prosecution did not call a witness. That's if this is what came from what my argument looked like, it was not what was intended. What is intended, however, is to support what my colleague from the prosecution said was inappropriate in the Borovchanin final brief. He argued that it was improper to suggest that it's unsafe to make inferences on the basis of evidence when you know that evidence is missing. So it's not drawing a negative inference about the prosecution's conduct. It's the fact that when the time will come for the trial chamber to draw an inference, if there is information that is missing, if there is information that would have assisted the trial chamber in leaning one way or another, then definitely the benefit must go to the accused, and that inference cannot be drawn. To use an example, the example I use is, of course, who ordered the military police to go to Oraovac on the evening of 13 July? There is evidence that Jasikovac ordered the military police to go to Oraovac. There's direct evidence about this by some witnesses, namely Stevo Kostic. However, the involvement of PW 168 into how and who told Jesse Kovacs to go to Orahovac, the trial chamber will have to make an inference. Because Jesse Kovacs was not called as a witness and could have been called, then there is some critical information missing. And because that critical information is missing, then the trial chamber will have to make an inference where the doubt will benefit to the accused. And the accused in this case is the man who we say never called Dragan Obrenović that night to report to him information he would have received from Popović. So the missing information will prevent the trial chamber from drawing, in certain circumstances, negative inferences against the accused. That's what we're saying, Mr. Judge.
Thank you. I have now just two legal questions for you, Mr. Bourgon. I have, of course, read carefully the arguments outlined in the brief on these various issues, so my question on forcible transfer is quite limited. But I'd like to know, with respect particularly to the individuals, the men separated at Potocari, is it your proposition that were an army to take control of a town, it would be lawful, a town where there has been allegations of opposition army members being present in that town, would it be lawful for them to, upon entering the town, to go to every house and take into custody every able-bodied man and place all those men onto buses and move them out of that town? Is it your proposition that where there's an allegation, a suggestion that the armed forces of the opposition have been present in the town, that it's lawful to take that action and it doesn't constitute forcible transfer?
My answer is yes, Judge.
So it is lawful to do a search of houses, take individuals into custody, and remove them from the town in those circumstances?
Absolutely.
And
If an army takes over a town and there are still members of the opposing force present, it is lawful for the attacker to detain all members that are left behind, to detain them and to hold them as prisoners of war, and to transfer them or to transport them to various detention facilities.
And this is without conducting any sort of determination, any sort of interview process, any identification of arms, any indication that these individuals are members of the armed forces of the opposition. It's still lawful to take those individuals, place them on the buses, and remove them from the town.
Judge, that is a completely different question. Whether these people have been properly identified as members of the opposing force left behind. There needs to be a screening process in accordance with international humanitarian law. Every army in the world has all kinds of directives that they use in order that when they detain somebody, then the first thing that needs to be done, they must be sent to a detention facilities where immediately every single alleged prisoner of war will be given an opportunity to argue against the fact that he is a prisoner of war and that he or she is a civilian. Now, when this screening process will take place, that does not have to take place necessarily in the next 24 hours. But if there are reason to believe that these members are members of the opposing force, they can be detained lawfully until this screening process will take place. Yes, Judge.
Thank you. I have your point on that. And finally, I'm just, perhaps is motivated more by curiosity, but I'm quite curious about your remarks relating to conspiracy, because I'm not familiar, I'm well familiar with the law of conspiracy as I know it in my own system, but I'm not familiar with this temporal limitation that you're suggesting on the law of conspiracy. For example, were I to today enter into an agreement with Judge Agius to commit some criminal activity, and tomorrow Judge Agius and I were to discuss that and receive the agreement of Judges Kwan and Stolle to participate in that same agreement to commit criminal activity, as far as I'm aware, that would constitute conspiracy on the part of all four of us in the same conspiracy. I wasn't aware that there's any temporal suggestion to the law of conspiracy and when the individuals have to enter into the agreement, albeit the agreement, of course, is the actus reus of the offense. Could you perhaps just comment on that for me, please?
Yes, Judge, absolutely. Both theories have been argued before the International Criminal Tribunal for Rwanda. The theory that you propose, and there's that that conspiracy is a continuing offense where you can become a member to the conspiracy, but this view has been rejected before the ICTR. Unfortunately, I cannot give you the exact case in which this has taken place. However, our view is the following. Once two persons decide and get into the agreement to commit a crime, and then once the crime has begun, we move into a different scenario. The person coming in after the crime has begun, after the train has been set in motion, that person is not a member of the conspiracy. He's a member of the crime. And if that crime happens to be committed through a joint criminal enterprise, then he becomes a member of the joint criminal enterprise if, of course, he has a necessary mens rea, and if, of course, he does something to significantly contribute to the furtherance of the common purpose or of the criminal plan.
So just that I'm perfectly clear, you would say that the limitation arises once the crime has commenced. That's on your argument, that there's no longer an ability to become part of the conspiracy, and not once the crime has been completed.
That's exactly our position, Judge. Once the crime has begun, the conspiracy is over.
Thank you.
Thank you. I have no. I did have one also in relation to the time when one can join a conspiracy, but I think most of it has been covered by Judge Prost and you in your answer. So I leave it at that.
Mr. President, can I take this opportunity to make a few corrections in the transcript
Yes, please.
that have been brought to my attention? The first one is at page 26, line 2, where I said in the transcript this morning, I said that, of course, it is not, it is an element of the crime, and I should have said that, of course, it is not an element of the crime. Our position is that it's part of the definition of the common purpose. The second place is on 8th of September, line 2. Line 2, 34479. I'm not sure if I made the mistake or if it was just it's my mistake. I've been told it's my mistake, so it's my mistake. I mentioned Rogocevic and I should have mentioned Orawat. That's 8th of September, line page 34479 at line 2. One last corrections I need to make. Another of my mistakes, maybe it's too much coffee or lack of sleep, I'm not sure. I mentioned that 70% of the members of the column were on ABIH lists. This is not actually what I should have said. I should have said that it's from 70 to 73% of the complete missing persons from Srebrenica who were on ABIH lists. And I think the distinction is important. And I think my colleague will agree that this is what I should have said on this occasion. Thank you very much, Mr. President. I also would like to take 1 minute simply to say thank you to the staff of this team. They've been working very hard. And Mr. President, it's very tough to have legal assistance in these defense teams because of the working conditions. And I'm really grateful for those people who have worked with us throughout this case, and I want to publicly acknowledge them. Thank you, Mr. President.
Thank you. Now, Mr. I don't know, Mr. Lazarevic or Mr. Gosnell?
Thank you, Mr. President. My colleague will need some setup time for a visual presentation that will be accompanying my closing remarks. I've done some calculations in my head, and I believe that you could take the 25-minute break now and then go in one interval until the end. So if that's to your liking, that would be our
Yeah,
preference.
but you need to calculate then the time we will have to the end. If we take a 25-minute break now, it means basically we'll restart at 12:15. 1:15, 1:15, yeah, it should be okay. It should be okay. Agreed? All right, that's fine with us, and that's what we will do. Thank you.
All rise. Fiquez-vous le